Well, greetings to you, ladies and gentlemen, and welcome to another lesson of law of contract. And today we're going to be on part three, which is our last component of the law of contract. And we are simply going to be looking at some of the elements of the contracts, explaining them into detail, and then we're going to be looking at the breach of a contract and the remedies that are available thereon. Right, some of the concepts, ladies and gentlemen, like breach of contract and the remedies that are available may be similar to what you have heard, but now we're going to be discussing them in a much broader context. So we're going to be starting with legality. Remember, amongst the elements of a contract, we said for a contract to be valid, there must be also the element or the part of legality. Right, so the third essential element of a legal contract is that of legality. Generally speaking, an agreement must be legal to constitute a valid contract. In other words, the contract must not illegally violate a rule of law. At a basic level, a contract may be said to be illegal in two situations. The first being where the contract or the performance itself would contravene a statute or an act of parliament. For example, section 60 of the National Health Act of 31 of 2003 prohibits the sale of human tissue, for example, kidneys, between private individuals. A contract where one party agrees to sell their kidney to another would be invalid on the basis of its illegality. So that is on the basis of a statute that abantu abanakwazi ukuthengiselana amalungu omzimba entering into a contract for the sole purpose of selling, for example, your kidney in exchange for money, and saying that if I give you my kidney, you're going to give me 100,000. That cannot constitute a valid contract, and therefore it does not really meet the standard of being a legal contract. Therefore, it's not a legal contract. All right, you must remember that bodily organs, human tissue, are donated, ladies and gentlemen, and that they are not sold because of the available legal provisions. I trust that we are together. The other legality is on the issue of selling your child. We know that that is absolutely not possible for you to actually sell your child, or I'm not ready to have a child and I'm taking it in exchange for money. That cannot constitute a valid contract. Umntana can simply be taken, depending on the age and the requirements thereon, to the adoption agency, where it does not pertain issues of an agreement that pertains to selling a person in exchange for money. That would be the issue. You can decide to donate, and an agreement can be to that effect, but where the component of it involves selling it, then that contract cannot be valid. I repeat, you can be able to donate, you can be able to take your child for the adoption, but the issue there is selling for the purpose of what I have actually alluded to. Right? So where the contract or the performance would contravene the common law, our courts have found that certain types of agreements are invalid for being contrary to the common law. For example, contracts injurious to the state, contracts proposing bribery of public officials, or contracts encouraging crimes. A contract where a hitman is hired to commit murder are illegal and therefore void. So this, in essence, ladies and gentlemen, means that any act that in itself or in its nature would be contra bona moris, in other words, would be against the law, right? Any act that is generally against the law cannot therefore be said to give ability to enter into a contract on that basis. What do I mean? Awunawukwazi ukungena kwi-contract ngento engekho semthethweni. Alright? If you, for example, are facing a challenge where you are taken to court on the basis of, let's say you drank whilst you were driving, right? You drank whilst you're driving and then you were taken to court, and then you cannot enter into an agreement with the prosecutor that, look, make this case go away, I'll give you 500 rand. That cannot constitute, because the act in itself contravenes common law. It constitutes bribery. Same applies with hiring a hitman. Shema besekuchiyo uthi khawuyodubula la mfazi and funa umbona okanye khawuyokwenza u-A no B no C ubulala bonke abantu la community. Ase ingasenzi uthi we entered into a contract. That contract is a contravention of common law, and therefore it cannot be said to constitute a valid and binding contract, because the act itself contravenes the law. So the other element, we spoke about legality, now we're going to be talking about possibility of performance. Ngokwesixhosa xa siyitolika sithi mayikwazi ukwenzeka le contract, right? It must be something ezawukwazi ukwenzeka. The fourth essential element of a contract is that performance should at least be possible. Thus, a purported agreement will be null and void if at the time it was entered into, or at the time performance has to occur, it was discovered that it will be impossible to perform the contract at all. As far as initial impossibility is concerned, the impossibility must be absolute. For example, the sale of a non-existent thing, like a unicorn, is absolutely impossible to perform. On the other hand, someone selling your cat or fish next year is fine because it can come into existence, right? In other words, it's something that can be possible to be done. So it is not something that is what is impossible. All right. So when we talk about a unicorn, we talk about a legendary creature that has been described since antiquity as a beast with a single large pointed or spiral horn projecting from its forehead, right? So it's one of those things again, esizithembisa abantu okanye sizithembisa abantwana sithi sawuzenza singenzeki. That is an impossibility, because where are you going to get a unicorn, right? On the other hand, if uthi kulo nyaka uzayo your next kettle of fish ndizakuthengisela zona ezi ndizifumanayo, then it's not impossible. It's something that can possibly happen, right? It is possible for a contract to be rescinded on the basis of supervening impossibility. In other words, although the contract can be performed initially, circumstances arise on which render the contract impossible to perform. So it is important, therefore, to note that the impossibility must also not be at the fault of the other party. In other words, you cannot escape a contract of sale of your house on the impossibility of performance if you burn down your own house. In other words, ladies and gentlemen, as we have said, it can now become impossible for a contract, or rather for there to be performance on a contract. Umzekelo ngulo wendlu, indlu ivele iche out of the blue. It's not out of your own doing. Then on that basis, the contract can be rescinded because it was impossible to perform that contract. But that impossibility, in order for you not to be liable for a breach of a contract, that impossibility must not be done by you. Are we together? So, in a nutshell, in the esiyithethayo apha sithi it must be possible to perform low contract leyo. Loo nto oyithengisayo mawukwazi ube uyayithengisa, but it may arise that during the course of a sale, kube impossible ukuba sayithengisa ngenxa yoba indlu yethini itshile. Are we together? And then the fifth important element of a valid contract is that any formalities which attach to the contract must be complied with if there are any. There are words that, if there are any, are very important. The general rule in our law is that no special formalities are required by law at all for the conclusion of a contract. In other words, this means that a contract does not have to be reduced to writing in order for it to be a valid contract. Nor does it have to be signed, as many people believe. An oral contract is an entirely valid contract in our law. Many parties prefer to write down their contracts and sign them in order to have conclusive proof of the terms of the contract and that there was consensus between the parties. But for most contracts, this is not the requirement. So generally, ladies and gentlemen, abantu bacinga ba kuze i-contract ibe valid funeka bebhale phansi ba uthi mhlawumbe uboleke umuntu imali athi umuntu ndiza kusecourt, hayi iza nento ebhaliweyo ipnetshoyo ba ndiboleke imali ndiza kunika. In terms of the rules of the court, ladies and gentlemen, if you can be able to ascertain lead evidence in court that on such a day we entered into an agreement, mhlawumbe ukwazi ubonakalisa into yoba through a check, through deposit, right, umdepositele 100,000, right, wamfakela 100,000 ebhankini, ubonakalisa so slip ebhankini uthi na 100,000, so sithethile ke ngoku uzophinda umnike, akho nto ke ngoku ephinde yabuya yaveza le mali ibuya. That is an oral agreement, right? As long as you can be able to adduce evidence. It may well become difficult ke ngoku if uvele wamnika esandleni lo mntu le mali akho mntu onibonileyo. You know, it's on a balance of probabilities. Therefore, you know, the scale there is very, very, very loose. It's very weak. So yeah, so it is mostly preferable that the contract be in writing, so that at least you don't have difficulties when it comes to having to prove certain things that you need to prove. But needless to say, or be that as it may, an oral contract is still a contract that is valid in terms of the law. That is formalities. But however, ladies and gentlemen, certain forms of contract are considered to be so important that they must be reduced, read to writing, be signed, and even have specific terms attached to them. And Parliament has passed legislation to confirm this. For example, the Alienation of Land Act of 1981 confirms that contracts of sale of property, houses, flats, or land must be in writing and registered in the deeds office. A verbal agreement to sell a house is therefore not a valid contract because it does not comply with the requirements of formalities. We here say, ladies and gentlemen, that ngamanye amagama awunawuyithengisa indlu ngomlomo. Singayithengisa, singavumelana ngokwemoto, ndithi ndiyakuthengisela le moto ina-50,000 rand yakho, awunawuyenza ngendlu loo nto, anawuvumelana ngomlomo. You must be prepared to prepare a deed of sale, so that kuzokwenziwa ilo deed of sale izofakwa a deeds office, right? Izofakwa a deeds office so that uzonikwa a title deed from the deeds office. That is what constitutes a valid sale agreement of a property. But le yoba ungakwazi uthengisa ngomlomo is against the requirement of alienation. But any other agreement, ladies and gentlemen, can be entered into by means of an oral agreement. Trust that we are together. This legislation prescribes. So now we are going to look into what exactly constitutes, because you remember we have laid down the elements of a contract and explained them into detail as to what constitutes a valid contract. So that contract, ladies and gentlemen, there's what constitutes a breach of that contract. In other words, go pulwa kwemiqathango yellow contract. Let us look at what that means and the consequences of that thereon. Once a valid contract is concluded, certain duties on one or both of the parties or of the contracting parties come into being. The nature of the duty depends upon the terms of the contract and the type of the contract itself, right? In other words, for example, to pay for property in the case of sale, or to make a room available in the case of a lease. So could depend on terms of contract, that in order for you to have purchased this house, we also have a suspensive clause in a contract of sale. Opposite corner, provided that within 30 days we uyibhatala le ndlu, ayizuba yakho, izaba yakho only obhatala le ndlu le nantsika within 30 days, and therefore xa ungayenzi within 30 days, that constitutes a breach of contract because it was in terms of the clause. Or in terms of a lease, urentisa indlu, make the room available within 10 days. In other words, awunawutsheka indlu uvalela umuntu ngaphandle ungamnike nezikhiya, and then uthi the contract has commenced. The contract commences once you have made the room available for leasing. Are we together? So a breach of contract occurs where one of the parties fails to perform her contractual obligations as contained in the terms of the contract. A breach of contract may be committed by either party to the contract and in respect of one or more of the obligations created by the party. Are we together, ladies and gentlemen? So if one of the parties to the contract, it either might be the seller or it might be the purchaser, both those parties in a contract of sale, because in a contract of sale you have a seller and a purchaser, they may be able to reach the obligations that are created by the contract, either the seller by making available the property or the purchaser by making available the money to buy that particular property. So we're going to be looking at the forms of the breach. A breach of contract can take various forms. So we're going to be looking at what constitutes or the main categories of a breach that are commonly encountered in our law on our next slide. Let's go. Negative malperformance. That is the first form of a breach of a contract. Negative malperformance. Negative malperformance takes place when a party to a contract fails to perform timeously. For example, the party does not perform the obligations she is expected to perform at all within or at the time at which she is expected to do so. When the time for performance has lapsed and one of the parties has not yet performed, that party is said to be in mora. Mora means in bad faith, and the other party will be entitled to a remedy. For example, if it is agreed that the property will be delivered by the seller to the buyer by the end of the month, when the month end passes, the seller will be said to be in mora and thus in breach of a contract, right? So in other words, you entered into this contract, navumelana, right? Navumelana ngale contract yokuthi uzawumthengisela. For instance, it mostly happens to these people who are in remote places where you are buying a certain product for that person, and then athi lo product izawufika within 30 days. Mhlawumbe uyiboneke ngokuthi ithathe 2 months ufika lo product leyo. That is, in other words, there was performance, but that performance is negative and it constitutes malperformance. So the person therefore can be said to be in breach of that contract because there was negative malperformance in that case. Are we together? So there was performance, but the performance is negative. So you can therefore, on that basis, be able to sue the other party for a breach of contract, which can be the cancellation or request damages, because mhlambe lo product uyidinga at a certain time, and as a result of not kuyifumana on that certain time, you were negatively prejudiced, and as a result you suffered. For example, ingasebenza ku-case yebhanki, ithi ibhanki, you are going to give you this money within 10 days, right? We're going to give you 100,000. Let's say ubuqualifier and you they approved you. Ngapha wathi ndizawuthenga le ndlu nge-100,000, ndizawuthenga le ndlu nge-100,000, right? Idlule ke i-10 days bangakunikanga le mali, adathi laa mntu hayi ke ayidlulile ke i-10 days, so asazi ukunika imali. Then the bank doing what constitutes negative malperformance. Are we together? The other aspect, or the second aspect, is defective performance. Positive malperformance. Positive malperformance takes place where a party to the contract renders defective performance. For example, does not perform in the manner in which that is contemplated in the contract. Umzekelo, a contract may stipulate that the seller is to deliver 100 kgs of Heineken to an October festival event. If the seller delivers 90 kgs of Castle Lager, then that performance would be defective in terms of the contract, right? There are many examples, ladies and gentlemen, that you can bring in this regard. For example, ndithi apha ndithengisa umshini okwazi ukwenza i-popcorns, or umshini okwazi upheka, or i-air fryer, right? Usikufumanisa into yoba ngoku le air fryer xa kufanele into yoba ngoku ipheke yona nje iyawomisha qha, but it does not go to the point where ipheke. Alright, so that is defective performance, because the contract stipulated that uzawundinika umshini owenza olu hlobo, so it does not therefore perform at its optimum level. It does not perform what the contract alleged that it is able to perform. Okay, same applies nakulo mzekelo. Abantu aba, let's say preference yabo kuthengisa uHeineken kule nantsika, but abantu ngokubona bavele in fact abantu befuna iHeineken, they made a deliberate request nisokuba nizenzele ipart basifuna iHeineken, then kuze isavana mhlawumbe. That is defective malperformance kuba esithi siphelele stock. Okusalayo in terms of the contract, you had promised that you are going to do A, no B, no C, right? Are we together? So that is what constitutes defective or positive malperformance there, right? There was performance, but it was then let's get the other, which is reputation. Repudiation takes place where one of the parties denies the existence of the contract or some material provision thereof. In fact, it occurs where either party to a contract by his words or conduct and without lawful justification communicates to the other party his unequivocal intention to no longer be bound by this contract. Umzekelo is where a party says to the other, I never agreed to this, despite the terms of the contract showing that he did. This denial in itself is a form of breach. Please note that a contract is not automatically terminated due to one party's unilateral repudiation of his contractual obligations. Thirdly, the innocent party has a choice as to whether to accept the repudiation or not. If he accepts it, he acquires the right to cancel the contract. If he elects not to accept the repudiation, the contract will remain in force and the innocent party will be entitled to enforce that contract in the courts. All right, so it happens, ladies and gentlemen, that parties in contracts may really say ngomlomo wabo bathi hayi khange ndingene mna kulo contract layer. That refers to reputation. So it is not on that basis terminated that you unilaterally repudiated your contract obligations, right? The innocent party has a choice as to whether to accept repudiation or not. So if he accepts it, he acquires the right to cancel the contract. If he elects not to accept the repudiation, the contract will remain in force and the innocent party will be entitled to enforce the contract in the courts. Are we together? Then look at the other, prevention of performance. Remember now, looking at forms of a breach of a contract. Prevention of performance takes place where a contractant negligently or intentionally performs some act or omission which makes performance impossible. Either party must make performance of the obligation impossible due to their committing act which is either negligent or intentional. Using the example in above, for example, if the seller was unable to deliver 100 kgs of Heineken to the Oktoberfest event because the buyer refused to allow the seller's truck onto their festival grounds, that would be an example of the buyer's breach in the form of prevention of performance. All right, so it can be on the side of the buyer as well, that lo mntu uvale igate sibangafona sithi sicela uvulelwa akafuni, so that therefore prevented or it hindered and thus made it impossible for the seller to be able to deliver performance to the other party, right? So it is important for you to note that this breach of contract can happen from the side of the seller or it can happen from the side of the purchaser, as we have seen in this particular example. So let us look at now the remedies for breach. In other words, what remedy is available for the breaches that, or the things that we said constitute a breach of contract in terms of what is said above. The objective of the law of contract is to bind people to what they have agreed to. Where one of the parties failed to perform as agreed, he is said to be in breach. A breach of contract by one party entitles the other to a remedy, an order of the court which is designed to undo the damage and the inconvenience caused by them breach. As we have seen, ladies and gentlemen, that each and every breach, whether it be positive performance, defective, preventative performance, all of them constitutes an inconvenience to the other party. Therefore, there has to be an order of the court which is sought in order to undo those particular damage. So if you have entered into a contract and the other party commits some form of breach, you may want one of the three basic things to happen, right? In other words, there are three things that you want to happen on the basis that there was breach of contract. Number one, you may wish to force the other party to perform in accordance to what they agreed to. In other words, this is called specific performance. So ubuthe uzawundithengisela le ndlu, right? Ubuthe uzawundithengisela le ndlu, so I require you therefore to pay this money. Or ubuthe uzawuzondichebela le nqa, ubuthe uzawundenzela le nto. Therefore you may go to court and seek a court order that requires him to perform the specific performance, because when as the other party you have met the bargain of the other deal, right? So you want the court to order him to pay. You want the order to not pay, but to perform that specific performance. That if the court orders that if he refuses to do A, B, and C, and D, then he may be liable, because obviously when you breach a court order, you are in contempt of court. Therefore, you may be arrested. Right, so you require that specific performance that you required initially from that contract to actually be enforced. Are we together? Secondly, you may wish to withdraw from the contract completely. This is called rescission or cancellation of the contract. So ungathi hayi mana le nto ayindisebenzeli mina ngicela siyicancellation le contract. Omnye ahambe indima yakhe nomnye ahambe indima yakhe. Kucacile uba le nto lena ayisasisebenzeli ngoku. Kucacile into yokuba le nto ayiyo le nto sasivumelene ngayo, so ndicela siphume kwesi sivumelano, siphume kule i-contract. Are we together? So that one can be therefore, defined as withdrawing from the contract, right? The consequences that may flow, they are not necessarily depend on what the party sought in the court order. So then the last one is, you may wish to recover financial compensation for any loss you might have suffered as a result of the breach. This is to claim to damages. Siyawuya kula mzekelo again lo Heineken, uzaba ne festival, uzaba ne party, ba deliverishe inansika iCastle Lager instead of Heineken engu 90 kgs. So when une festival ne event, you had anticipated okanye ubuthembise abantu into bazaba notywala obungaka, abantu basike bangabuthengi obutywala bushiyeke pha because abantu bathi ha kaloku asifunanga Castle Lager thina sifune iHeineken, right? So now you are going to suffer a loss because zizawuba khona ezo nto ezo zawuhlala nje pha azizuthengo, because wena uthembise abantu ngeHeineken obathembisa ngeCastle Lager, abantu abayifuna iCastle Lager badikiwe kwayile nonsense obanika yona because wena ubathembise ntoni, ubathembise loo nto. So therefore you are going to suffer loss. You contemplated to make profit, but you're going to suffer loss because what was delivered was not what you initially expected. It was a defective performance. So there you may make an application to court, not make an application, but you can issue out summons to court for the purposes of being able to recover the loss that you may have suffered as a result of the breach of that particular contract. Right? I trust that we are still together. The law provides you with these options depending on the circumstances of each case. Note that damage as a remedy is often available together with specific performance or cancellation. So each damage is not singled out as a single thing. Because you must remember, as I said, any remedies specific performance. Sifuna uyiperform lento uzoyenza ngenkani by fire by force, but law application, law request may be accompanied by request yet damages as well, because also yenza ngeli xesha nangalendlela benifuna yenze ngalo. So my catch was the damages ke ngoku, for the damages that I suffer, for the loss that I incurred. In other words, lo mntu akazisanga le Heineken uze neCastle Lager, I request the court, no, he must be ordered to bring a Heineken, and on top of that makabhatale imali damages as a result of loss. Same applies with the cancellation. Ungathi ansafuna ibona le cancellation, ansafuna ibona le contract de cancellation, kodwa mayikhathwe zindleko because I suffered as a result of non-performance of this particular contract. So sizokumzekelo ke, if the seller failed to deliver 100 kgs of Heineken to the October 1st event, the buyer will need to source the beer at the last minute, and it will be likely at a higher price. The buyer in this case can cancel the contract, claim their money back, and therefore claim the damages in the form of difference between the original contract price and the price paid to them third party for the beer at the last time. So uzocela le mali wena ubuyibhatele nemali lena uyisebenzileyo ke ngoku subsequently ukuthenga izinto, because obviously xa uzithenga usaquphe you'll pay a higher money kuba uzithenga last minute. That therefore gives you the ability to have indoni a remedy that is of that particular nature, that you can be able to claim both damages and cancellation, or damages and specific performance. Specific performance. The object of a claim for specific performance is an order compelling the other party to perform as they had agreed to perform in terms of the contract. The general principle is that a court will order specific performance in favor of a contracting party when, number one, the party has himself performed in terms of the contract, number one. Secondly, performance is possible at the time the order is sought. Number three, the resulting of granting such an order will not produce injustice to the party against whom what is directed, right? So we are going into general detail and general elements of under which circumstances can you be able to require. Possible, because remember the defense of impossibility at that particular time, right? So you cannot require specific performance insurance ezawufika ilungise ngaphandle into yoba ayitshiswanga nguwe ke. And again, the other party will not be prejudiced as a result of inconvenience yakho yokuyifuna yenzeke lento kodwa nawe uyayibona ba under these circumstances ayenzeki. And the first one being ke into ba nawe kwawena uyibhatele kwakuqala imali yento ba le contract lena ikwazi into ba ithini iperformeke. Rescission, cancellation. A prejudiced party may decide that he would prefer to end the whole nightmare and revert to the position in which he was before into the agreement. This can be done by rescinding, also known as cancelling the contract. Cancellation is a drastic remedy and the law of contract does not allow it lightly. The purpose of law of contract is to create as much certainty in commercial circumstances or commercial transactions as possible. Therefore, an aggrieved party will only be entitled to a contract in the following circumstances. A claim for damages is aimed at placing the injured party in the position that she would have been in had the contract been properly performed. Damages may be claimed for either a major or a minor breach and may be claimed in conjunction with any of the above remedies. In order to succeed in a claim for damages, the injured party must prove that number one, that the breach was committed by the other party or his agent. In other words, for you to claim damages kufuneka kubonakalise into ba le breach yenzwe ngolomnye umuntu okanye agent yakhe, lo muntu bekufanele uba unento ayenzayo angakwazanga ukuyenza. So mangabe yenzwe nguwe, like la impossibility to perform besithetha ngayo, that when you have made it impossible into ba lo muntu makakwazi ungena kule gate adivariso le Heineken, so uzodinga undayicancela le contract on that basis because of ego zakho. Are we together? Secondly, that he or she suffered loss as a result of the breach. In other words, kufuneka ukwazi uyibonakalisa through his statements, ukwazi uyibonakalisa uyiveze into ba I have suffered loss. Benine proposal, nina hlala phansi nabona into kokuba thina uba siyayenza le festival sakwenza i100,000 okanye sakwenza i500,000 bakufika iHeineken sawuthengisa iHeineken ezingaka zenza profit yangale mali. But when you discover that all of a sudden that you have spent more money than that you are actually able to retrieve, so uzabonakalisa ke ngoku documentation that you suffered a loss as a result of this breach. In other words, nguwe ukhuphe imali eninzi and as a result usafumani ngoku, so you can ask damages from that none compensate me, and the court will grant you that particular order because you are the party that has been prejudiced and you are the party that has suffered damages. Then lastly, that the breach was not caused by pure chance, that the damages were foreseeable by the defaulting party at the time the contract was entered into. Izawuphinde buyele okokoko kula mzekelo bendiwusebenzisa wendlu echileyo, or if you're going to lease indlu all of a sudden because of a storm idilike lo ndlu leyo, you could not have possibly foreseen, especially if lo ndlu leyo ibiqinile, you had put in the relevant safety measures, it was approved by the council, everything was done in order. You could not have reasonably foreseen that actually kungenzeka i-damages up, right? In other words, you would not have foreseen that andizokwazi uyithengisa le ndlu ngenxa yesizathu sika A no B no C no D. I did not foresee this thing happening. But if you are intentionally negligent, for example, le ndlu uyayibona manje indawo ekuyo ukuba uyithengisa into yoba ndiyithengisa kwendawo apho if kunganetha khona, right, if kunganetha khona kule ndlu yo kunga out apha kungaphandle, you knew that, you reasonably foresaw that, then what is going to happen, ladies and gentlemen, is that you negligently breached that contract and therefore you're going to be liable for what? For damages, right? So those are the conditions, guys, in terms of which, ladies and gentlemen, you can be able to actually do that. So, ladies and gentlemen, thank you very much for your time. This brings us to an end of our lesson, Law of Contract. Thank you very much for your time, and I trust that you are going to learn much and that you are going to really understand law of contract and use it as you are going to be a chartered secretary or a company secretary, that you're going to be understand the components, the elements of a contract, and what constitutes a valid contract. Thank you, ladies and gentlemen, and God bless.